Hello friends, welcome to iExamB's Law Channel Legal B. We started 300 most important law question series, and yesterday I gave you a Google form having 20 questions from Code of Criminal Procedure. In this video we are going to discuss those questions, explanation and solution to those questions. We started this series on 23rd of September and this will continue till 30th of December. There will be 15 tests in this series. Today we are going to discuss Criminal Law CrPC. On 14th of October, you will have a test from Law of Contracts, Contract Act and Specific Relief Act. Come prepared and make the best use of these questions, make the best use of these series. Starting with question 1. In a cognizable offence under IPC, the police will have all powers to. The correct answer is investigate, including the power to arrest without warrant. In a cognizable offence, the police has a power to arrest without warrant. This is given under section 2 subsection C of CrPC, which defines cognizable offence. It is an offence for which, and cognizable case is a case in which a police officer may arrest without warrant. And then section number 156 talks about police officers' power to investigate cognizable case. It says any officer in charge of a police station may, without the order of magistrate, investigate any cognizable case which a court having jurisdiction over the local area within the limits of such station would have power to inquire into and try under the provisions of Chapter 13. Question 2. Classification of compoundable and non-compoundable offence is provided under. The correct answer is section 320 of Criminal Procedure Code. Section number 178 talks about place of inquiry or trial. 320 talks about compounding of offences. 321 talks about withdrawal from prosecution. First schedule deals with classification of offences and second schedule with various forms. Moving to question 3, a proclamation requiring a person to appear must be published giving. The correct answer is not less than 30 days time to the person concerned. So proclamation is requiring a person to appear within a period at most 30 days. This is given under section number 82 of Criminal Procedure Code. Question 4. Complaint as provided under section 2 subsection D of Criminal Procedure Code can be either in writing or oral. Correct answer is C. This is defined under section 2. Complaint means any allegation made orally or in writing to a magistrate. So complaint is not FIR, it is not made to a police officer, it is made to a magistrate with a view of his taking action under this code that some person, whether known or unknown, has committed an offence but does not include a police report. Question 5. A warrant of arrest is a command. The correct answer is all ABC. A warrant of arrest must be in written order. It must be signed, sealed and issued by a magistrate, and it must be addressed to the police officer. This is given under section number 70 and 72 of Criminal Procedure Code, which talks about form of warrant of arrest and duration. Every warrant of arrest issued by a court under this code shall be in writing, signed by presiding officer of such court and shall bear the seal of the code. Section 72 talks about warrants to whom directed. A warrant of arrest shall ordinarily be directed to one or more police officers, but the court issuing such a warrant may, if its immediate execution is necessary and no police officer is immediately available, direct it to any other persons or person, and such person shall execute the same. Question 6. Judges in the Court of Session are appointed by. The correct answer is High Court. Court of Session judges are appointed by High Court. This is given under section number 9 of Criminal Procedure Code, which talks about the Court of Session. There shall be a Court of Session for every Sessions division. Every Court of Session shall be presided over by a judge appointed by the High Court. Question 7. Chief Judicial Magistrate may pass a. The correct answer is sentence of imprisonment not exceeding 7 years. This is given under section number 29 of Criminal Procedure Code, which talks about sentences which a magistrate may pass. The Court of Chief Judicial Magistrate may pass any sentence authorized by law except a death sentence or imprisonment for life or imprisonment for a term exceeding 7 years. Court of Magistrate of first class can pass a sentence of imprisonment for a term not exceeding 3 years or fine not exceeding 10,000 rupees. Of second class may pass an imprisonment for a term not exceeding 1 year or fine not exceeding 5,000 rupees. Moving to question 8. Every summon issued by a court under CrPC. Correct answer is shall be in writing, in duplicate, signed by the presiding officer of such court and shall bear the seal of the court. Though all the other answers may also seem correct, summons shall be in writing, in duplicate, signed by the presiding officer. This is correct. It shall bear the seal of the court. It is correct. But here we have to find the most appropriate answer, and the most appropriate answer is C, which includes all the points. This is given under section number 61 of Criminal Procedure Code, form of summons. Moving to question 9. The experience required to be appointed as Special Public Prosecutor is. The correct answer is 10 years. This is given under section number 24 subsection 8. The central government or the state government may appoint for the purposes of any case or class of cases a person who has been in practice as an advocate for not less than 10 years as a Special Public Prosecutor. Moving to question 10. Maintenance of a case diary by an investigating officer is. The correct answer is mandatory. Every investigating officer must maintain a case diary in which they are mentioning the proceedings of investigation on a regular basis. What they have done in the investigation on a particular day, that has to be entered in that case diary. This is given under section number 172 of Criminal Procedure Code. Every police officer conducting the investigation shall maintain a record of investigation done on each day in a case diary in the prescribed format. Case diaries are very important to record the investigation carried out by the investigating officer. Moving to question number 11. A police officer may arrest somebody accused of an offence to prevent such person from committing any further offence, for proper investigation of the case, or to prevent tampering of the evidence. The correct answer is all 1, 2 and 3. This is given under section number 41 of Criminal Procedure Code, when the police may arrest without warrant. Here, to prevent such person from committing any further offence, for proper investigation, to prevent such person from causing the evidence of the offence to disappear or tampering with evidence, to prevent such person from making any inducement, threat or promise, to ensure his attendance in the court whenever required. So for all these reasons, the police officer may arrest any person without warrant. Moving to question 12. Which of the following is true with respect to warrant of arrest? A warrant of arrest may be executed at any place in India. A warrant of arrest shall ordinarily be directed to one or more police officers. The police officer or other person executing a warrant of arrest shall always show the warrant to the person to be arrested. The correct answer is only 1 and 2. Point 1 related to the place of execution is given under section number 77. Point 2 related to whom the warrant can be directed is in section 72, and point 3 is in section number 75. Point 3, which is incorrect, says notification of substance of warrant. The police officer or other person executing a warrant of arrest shall notify the substance thereof to the person to be arrested, and if so required. So here, if so required, shall show him the warrant. Point 3 here talked about shall always show. That is why this is incorrect. Moving to question number 13. Maintenance under section number 125 of the Criminal Procedure Code cannot be claimed by. It cannot be claimed by a married daughter who have attained majority. This is given under section number 125, which discusses who all can claim maintenance. Question number 14. Under section 102 of Criminal Procedure Code, who is authorized to seize the stolen property? The correct answer is police officers. Section 102 allows police officer to seize certain property. Moving to question 15. In the trial of someone's case by a magistrate, point 1, charges must be framed. Point 2, it is not necessary to frame charges. Point 3, charges can be framed provided accused does not object. Point 4, only substance of accusation is to be stated. The correct answer here is 2 and 4. In someone's case, it is not necessary to frame charges, only the substance of accusation is to be stated. This is given under section number 251 of Criminal Procedure Code, substance of accusation to be stated. Moving to question number 16. Any court may alter or add to any charge any time before. The correct answer is before the judgment is pronounced, the court may alter or add any charge. This is given under section number 216 of Criminal Procedure Code, which talks about court may alter the charge before the judgment is pronounced. Moving to question 17, which of the following court is not empowered to transfer criminal cases? The correct answer is Court of Special Magistrate. Supreme Court, High Court and Court of Session has the power to transfer criminal cases. This is given under section number 406, 407 and 408 of Criminal Procedure Code. 406 talks about power of Supreme Court to transfer cases and appeals. 407 talks about power of High Court and 408 talks about power of Session Judge. Question number 18. A judgment contains. The correct answer is all ABC. Judgment contains concise statements of the case, points of determination, the decision on the points of determinations and reasons thereof. This is given under section number 354 of the Criminal Procedure Code, language and contents of judgment. Moving to question number 19. Application for anticipatory bail may be made before. The correct answer is D, both B and C. For anticipatory bail, the application can be made to High Court or the Court of Session. This is given under section number 438 of Criminal Procedure Code, which talks about direction for grant of bail to person apprehending arrest. The person has an idea that he may be arrested in future, so he applies for anticipatory bail either to High Court or the Court of Session. Moving to last question of this video, question number 20. When the High Court or any session judge calls for to examine the record of any proceeding before any inferior criminal court, it is called. The correct answer is C, revision. This is given under section number 397 of the Criminal Procedure Code, which talks about calling for records to exercise power of revision. High Court or any session judge may call for and examine the records of any proceeding before any inferior criminal court situated within its local jurisdiction for the purpose of satisfying itself or himself to the correctness, legality or propriety of any finding. The powers of revision conferred by subsection 1 shall not be exercised in relation to any interlocutory order passed in any appeal, inquiry, trial or other proceedings. So that's all. I am again saying next Friday we will be sharing questions on law of contracts, Contract Act and Specific Relief Act. Be prepared. You have one entire week to prepare for these topics. This will give you a good revision every Friday, and then you can cross-check your questions using this video. So this can help you in strategizing your preparation for SEBI legal, for IBPS, so PFRDA a lot. If you find this video useful, hit the like button, subscribe to our ExamBees YouTube channel. This is your one-stop solution for all legal exams. We bring a lot of videos relating to notifications, study plans, preparation video, practice questions, and a lot of other content. So check out our LegalBee YouTube channel and subscribe to this channel. If you have any queries, you can write them down in the comment below or call us on this number. Thank you.